This video is for educational purposes only and does not constitute legal advice. The radio interview featured is a reconstruction and not a real broadcast.
Welcome back to Legal Matters, where we break down the law in plain English. I'm your host, Sarah, and today we're talking about an important concept, the cause of action for conspiracy under California civil law. To help us make sense of it, we're joined by Professor James Whitfield, who's known for explaining legal concepts in ways everyone can understand. Professor, welcome back to the show.
Thanks for having me, Sarah. It's always great to be here.
Now, when most people hear the word conspiracy, they think of crime shows or secret plots. But what does conspiracy mean in a civil lawsuit?
That's a great place to start. In civil law, a conspiracy isn't a crime. It's a way of holding more than one person responsible for a wrongful act. We call it a theory of shared liability. It means that when two or more people agree to commit a wrongful act, and that act causes harm, each person involved can be held responsible, even if only one of them carried out the act directly.
So it's about shared responsibility for doing something wrong together.
Exactly. Think of it as an agreement, whether spoken, written, or just understood by actions, to do something unlawful or wrongful. Once that wrongful act happens, everyone who agreed to it can be held legally accountable.
That makes sense. So if someone wants to bring a civil conspiracy claim in California, what do they have to prove?
The law sets out a few key things. Let me explain it step by step. First, the person bringing the lawsuit, called the plaintiff, has to show that the defendant knew about a plan to commit a wrongful act. Second, the plaintiff must show that the defendant agreed to and intended for that wrongful act to be carried out. And third, there has to be an actual wrongful act that caused harm, something like fraud, interference with a contract, or another civil wrong. If those elements are proven, then everyone who took part in the agreement can be held responsible for the harm that followed.
Got it. So just knowing that someone else is doing something wrong isn't enough.
That's exactly right. Simply knowing about someone's bad behavior doesn't make you part of a conspiracy. The law requires more. There has to be agreement and intention to participate. However, that agreement doesn't always have to be written down or spoken out loud. A court can look at the circumstances, the people's actions, their relationship, and their shared goals, and decide that there was a kind of meeting of the minds.
That sounds like something that could get tricky to prove.
It definitely can. Proving a conspiracy often relies on indirect evidence because people rarely make open agreements to do something wrong. The court looks for patterns of cooperation that point to an understanding between the parties.
Let's talk about timing. What happens if someone joins a conspiracy after it has already started? Are they still responsible for what happened before they joined?
Yes, that can happen. When someone knowingly joins a continuing conspiracy, they can be held responsible for all of the acts that were part of the plan, even those that took place before they became involved. By joining in, they take on the legal consequences of everything that's part of that common scheme.
That's a big deal. Now, what about situations where someone is just doing their job, like an employee following their boss's instructions? Could that person still be accused of conspiracy?
That's an excellent question, and the law makes an important distinction here. Generally, if someone is acting within the scope of their job, carrying out their employer's business, not their own personal agenda, then they cannot be considered part of a conspiracy with the company. The idea is that a business can't conspire with itself. But if that same employee acts for their own personal benefit instead of the company's, then the protection disappears and they might be held liable for conspiracy.
So the key difference is whether they're acting for the company or for themselves.
Exactly. It all comes down to intent and purpose. If someone's actions are driven by their own goals and those goals align with the wrongful plan, then they can be brought into the conspiracy.
Professor, before we finish, could you summarize, in simple terms, what people should remember about civil conspiracy in California?
Of course. Here's what to keep in mind. First, a civil conspiracy happens when two or more people agree to commit a wrongful act. Second, there must be intent. They must actually mean for that wrongful act to happen. Third, at least one person carries out the act and it causes harm. And finally, everyone who agreed to the plan can be held responsible for that harm even if they didn't personally do the wrongful act themselves. And remember, conspiracy isn't a separate lawsuit by itself. It's a way to extend liability to everyone who participated in the plan.
That's such a clear explanation, Professor. Thank you for breaking that down in everyday language.
My pleasure, Sarah. It's always important for people, especially those representing themselves, to understand how these legal concepts actually work.
Absolutely. Well, that's all for today's episode of Legal Matters. Remember, this discussion is for educational purposes and applies to civil conspiracy law in California. If you're involved in a legal case, always seek professional advice from a qualified attorney. I'm Sarah, and you've been listening to Legal Matters. Stay informed, stay empowered, and we'll see you next time.